to our second speaker event of the year. We're very excited. Before we get started, the pizza is on its way, but we ask that you don't get up and get pizza while they
We'll take a break after my remarks, okay? So
we'll
we'll
have
take
like a little
intermission.
Where you can get your food. Okay, so I'm going to begin by reading our mission statement. So the Federalist Society is a group of conservatives and libertarians interested in the current state of the legal system and its philosophies and ideologies. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. The Society seeks both to promote an awareness of these principles and to present their application to its activities. In working to achieve these goals, the Society has created a conservative and libertarian intellectual network that extends to all levels of the community. So our first speaker, or star of the show, is Professor
The star? I'm not the
Yes.
star. I am not a star.
You are the star.
I am not worthy. I'm not worthy.
So Josh Blackman is a national thought leader on constitutional law in the United States Supreme Court. Josh's work was quoted during two presidential
Back-to-back.
He has testified before Congress and advises federal and state lawmakers. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and the leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law, Houston.
Yes.
He holds the Centennial Chair of Constitutional Law. He's also an adjunct scholar at the Cato Institute. He has authored 3 books, and his latest, Intro to Constitutional Law, was top 5 bestseller on Amazon. He has written more than 6 law review articles that have been cited nearly 1,000 times. He was elected by Forbes magazine for the 30 Under 30 in Law and Policy. And he is the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league.
You should all play.
And he blogs at the Volokh Conspiracy.
As does.
As does Professor Volokh.
Correct.
And he
Do you read
tweets
that
at
garbage?
Josh and
Garbage.
Blackman.
Thank you.
Okay.
It's a rag.
So our second speaker today, who we all know and love, our very own Professor Sasha Volokh. He is an associate professor of law and joined the Emory Law faculty in the fall of 2009. He earned his BS from UCLA and his JD and PhD in economics from Harvard University. He clerks for Judge Alex Kaczynski on the Ninth Circuit and for Supreme Court Justices Sandra Day O'Connor and Samuel Alito. Before coming to Emory, he was a visiting associate professor at Georgetown University Law Center and a visiting assistant professor at University of Houston Law Center. His interests include law and economics, administrative law and the regulatory process, antitrust, privatization, corrections, and legal history. So without further ado.
And he's an advocate before the Georgia Supreme Court. Don't forget that part. Thank you so much. I love coming to Emory. It was a lovely visit. So the topic today is the Second Amendment. So when Professor Volokh and I were in law school, the Second Amendment wasn't really a thing. I mean, it was in the Constitution, but there were no meaningful Supreme Court cases about what it meant. But in the span of 2 years, the court decided 2 landmark Second Amendment cases. First, in 2008, the court decided District of Columbia versus Heller. This case held that the Second Amendment guarantees an individual right to keep and bear arms that is not connected to any sort of militia service. This was a big deal when it happened, sort of shocked people because people thought the Second Amendment just didn't really have any significance. About 2 years later, the court decides a case called McDonald v. City of Chicago. This was sort of the follow-up. McDonald held that the Second Amendment is incorporated, that is, extends to the states. That is, the federal government can't violate the right to bear arms. Likewise, the state governments can't violate the bear arms. That wasn't too unexpected. But Heller and McDonald left a lot of stuff open. The only actual issue in those cases was, could the government ban the private possession of firearm in the home? Heller and McDonald said nothing, directly at least, about carrying a gun outside the home. Heller McDonald didn't speak to what kinds of weapons you could carry. The holding didn't concern what kind of magazines, what kind of ammunition you might be able to possess. It sort of talked about who might be dispossessed of a firearm. For example, dangerous people. It said dangerous and unusual weapons may be barred. People with mental illness sort of just hinted at this, but this was all more or less dicta, right? Didn't actually hold it. So in the wake of McDonald and Heller, most people were expecting, okay, the court will decide a steady diet, a regular course of cases concerning the right to bear arms. Except they didn't. In the years after Heller, the lower courts began to sort of decide gun cases, a wide range, and we're expecting, okay, those are nice lower court decisions. What will the Supreme Court do? Will there be sort of a clear ruling? And 2010, 2011, 2012, year after year, the court just started denying review over and over again. As you know, the court has discretionary review. They don't have to take cases. And they kept denying all these cases. And these lower courts almost consistently upheld every gun control law they found. They said, okay, this fits within the Heller framework, right? We're going to stick with this. And starting in 2014 or 2015 or so, Justice Thomas started dissenting, saying, wait a minute, we have this new thing, the Second Amendment case law, and why aren't we, the Supreme Court, deciding these issues? Why are we letting the lower courts figure it out? And there were splits, and they just let these splits pervade. And then eventually Justice Scalia got in the act, and they said, why are we treating the Second Amendment different, right? In other words, we have all these First Amendment cases, we have all these Fourth Amendment cases. Why aren't we taking any gun cases? And at the time, there was a lot of thinking about this. So Sasha Clerk for Justice O'Connor, she was no longer in the court, but Justice Kennedy, sort of the other moderate, still was in the court. The thought was maybe Justice Kennedy doesn't really want to go too far with guns. Maybe he's okay with a gun in the house, but he doesn't want to have a gun on the street. And even Chief Justice Roberts, who voted in the Heller majority, if you listen to his questions, he was very skeptical and wasn't too eager to have a robust Second Amendment right. So this was the status quo. They didn't take any gun cases in 2013, 14, 15, 16, 17. Okay. In 17, we get a new judge. We have Justice Gorsuch replace Justice Kennedy. So maybe that will result in some gun cases. And they still don't grant any. Then we go to 2018. We get Justice Kavanaugh to replace Justice Kennedy, right? And that was a much more significant shift in the court. The court did take one gun case from New York. It's kind of a strange case about keeping a gun locked in your trunk when you go to a gun range. Very unusual case. What did New York City do after the court granted review? They salted the earth. New York repealed its law, and they mooted the case out because they did not want the court to decide a gun case. Okay, so we go forward to the following year. We have another case from New York. New York had a law that's known as may issue. What does may issue mean? If a person wants a permit to carry a firearm, they have to basically ask for permission. They have to submit fingerprints, pay a fee, take a class, go through a background check. All that stuff is fairly, I think, uncontroversial. But then there's the part that upset people. It was discretionary. What does that mean? You only got a gun if you showed special cause or a specific justification of why you needed to have a gun. It wasn't enough to say, I want to defend myself. I live in a bad neighborhood. That's not enough. You just have a special reason. And as anyone knows with government, when you need a special reason, there's often very much favoritism. If you were a celebrity or a politician, you got your permit. If you were a regular person who lived in a rough neighborhood, you probably were not getting your permit. So this was challenged in New York. The lower courts upheld it. The Second Circuit affirmed. How can New York do this? So the case goes to the Supreme Court in a case called New York State Rifle and Pistol Association versus Bruin. It was almost entirely expected that the Supreme Court would reverse. That is, the Supreme Court would rule that, yes, there's a right to bear arms inside the home. Sort of the million-dollar question, though, is what exactly would the court say about it? This case was decided in a very contentious time, June of 2022. I assume you were all aware of this period. In the span of about a week, the court overruled Roe v. Wade and Dobbs. The court got rid of the Lemon test in Kennedy v. Bremerton, and the court decided Bruin, the Second Amendment case. This was the most significant three cases decided in a short period in my lifetime, maybe even in the last century, or at least close to it. The majority opinion in Bruin came to Justice Clarence Thomas. And if you don't think of Justice Thomas, he doesn't get many majority opinions that are of significance. He usually writes these sort of solo dissents and his concurrences. It's rare that he gets a big case by himself. But Justice Thomas got it. And he put forward what's a very, I would call it, history and tradition approach to the Second Amendment. And he said we have to look at different periods of time. We have to look at what were the sorts of laws that were around before the ratification of the Second Amendment, and then after the ratification in 1791, what sort of laws existed then. And it's questionable, why do we care what happened after the Second Amendment? In fact, Justice Barrett is very skeptical of this. We look to sort of this tradition of gun laws before and after ratification. And Justice Thomas surveys almost 1,000 years of history, going back to the Middle Ages. And he says, well, there's really no tradition of banning law-abiding citizens from carrying arms inside the home. And the dissent says, sure there is. There's plenty. There are these things called surety laws. That's S-U-R-E-T-Y, surety laws, right? And these surety laws say that if you were a person who posed a danger to someone else, the government can make you post basically a bond, right? Post a cash bond. And if you post this cash bond, you can keep your gun. And if you use your gun to harm someone, you surrender the bond to the victim. It was almost like a compensation system they developed. And there were also laws going back to the 1600s that said that if you were dangerous, you could not, carry a gun in the king's woods, so to speak, the king's forest. But Justice Thomas says, no, these aren't enough. The fact is, you could be disarmed if you were dangerous, but in Bruin, these were law-abiding citizens. These weren't people who had any sort of criminal conviction. These were good people. And about the surety laws, Thomas said, that's fine. All those laws say that if you were dangerous, you had to pay a fee, a small bond, and you could have your gun. That's different than New York, where they banned it altogether. You can't have a gun to carry. Okay. So Bruin was decided. It was 6-3, although his probably vote was a little bit closer than it looked. Justice Barrett had a concurrence saying, I don't like looking at this tradition after the fact. And then Justice Kavanaugh and Chief Justice Roberts wrote a concurrence saying, well, we agree with the majority, but we really like Heller. And Heller said you can't have guns with dangerous people. And Heller said this, you can't have dangerous and unusual weapons. They basically reaffirmed Heller. Okay. Barely a few months after Bruin was decided with a case from my beloved Fifth Circuit in Texas. The case is called United States against Rahimi, R-A-H-I-M-I. Mr. Rahimi is not the kind of guy you want to invite to your home. He's a bad dude. He beat up his girlfriend. He shot at many people. He shot up a Whataburger, right? He was a very bad, everyone know what Whataburger is? It's a Texas thing, right? Do they have them here or no? No.
Yeah, they just started coming over.
No way. You serious?
There's a bunch in Alabama.
I know they have in Florida too. So good. Anyway,
For those of you who are from California like me, it's
In and
how
Out.
you say in and out in Texas.
yeah, it's different though. We have in and out in Texas now too. Anyway, back to business. So Rahimi's a bad dude. So he basically shot at people. He shot up a Whataburger. He was a bad person. He could have been charged with a range of crimes, battery, assault, attempted murder, and so on. But for whatever reason, the good people in northern Texas never charged him with any sort of crime. He was never indicted for these offenses. But his girlfriend at the time sought what was called a DVRO. DVRO, what does that stand for? Domestic Violence Restraining Order. This isn't an order that exists, I think, in most jurisdictions where a partner can seek an order against their partner, for example, a husband, wife, boyfriend, whatever, and say, this person poses a threat to me. These are often issued ex parte, and they can be issued in very expedited proceedings where counsel is not present. It's a civil proceeding, but it has significant consequences. It says you must stay, 100 feet away from this person. You cannot harass them. And if you have any firearms, you must surrender them. Okay, so Rahimi got this order put against him. Surprising no one, he had guns, and he did not surrender them. So then the feds charge him, not with domestic violence, not with shooting people, but possession of a disqualified person, that he was a disqualified person because he had this restraining order. He had a firearm. Initially, under the older regime, he was convicted and he was sentenced to some time in jail. After the Bruin case, he said, hey, take another look at my case. The Fifth Circuit ruled in his favor. And here's what the holding said. They said, there is tradition of the government disarming convicted felons. That is, if you have a jury trial or a plea bargain, you're guilty, you can then be convicted. But there's no tradition of disarming you based simply on a finding of dangerousness by a magistrate, right? There's an ex post, that is, after you do something bad and you're convicted, you can be disarmed. But without a conviction, ex ante, they can't take the gun away from you. Now, we'll talk maybe about this later. I think the Fifth Circuit accurately read Bruin. I think that's exactly what Bruin said. So if you're a lower court judge, and these judges are called inferior judges for a reason, their job is not to anticipate what the Supreme Court might do. Their job is to decide the case based on the precedent that exists now. So I humbly submit that the Bruin decision, which looked to traditions, that is there a tradition of taking a gun away based on a finding of a civil magistrate? And the answer is no. There is no such tradition. So the case goes to the Supreme Court, and it becomes very clear from the oral argument that the Supreme Court is going to reverse the Fifth Circuit. The lawyer representing Mr. Rahimi was not Paul Clement. He was not an NRA lawyer. He was a federal public defender. And I don't say this to disparage PDs. They do extremely important work. But his goal there was not necessarily to get the best ruling for the Second Amendment. He was trying to get his guy off. That's his client, right? His client is not a public. His client is Mr. Rahimi. You like him or not, he's a client, deserves an advocacy, a zealous advocacy. So the arguments did not go particularly well for the lawyer. I think he did about as well as he could have, but the judges were basically eating him alive. At one point, Chief Justice Roberts was asking him about being dangerous, and he goes, I'm not really sure who's dangerous. How do we define that? Roberts goes, your client's dangerous. It's like, okay then. Okay, you're going to lose. Yeah. He's like shooting at people. That makes you dangerous. And it's like, okay. When you're look, let's be honest. When you're a lawyer, you have to hold the line sometimes. And if a judge chews you out, you're going to get hit. So you have to just take that. But it's like, your client is a dangerous one. So you're going to lose the Roberts vote at that point. But it was actually far worse than that. The vote was ultimately 8-1. Only Justice Thomas was in dissent. And again, Thomas wrote the majority opinion in Bruin not even 2 years earlier. So how did Chief Justice Roberts sort of make this work? And he's very smart. Love him or hate him, he's a brilliant man. And he's almost like a magician. There's always misdirection. What he's showing you is not what's really going on. It's really over here. He's like, look over here, this amazing language I'm using, and really the work's going over here. So here's how we did it. There are two types of laws that were being presented as a tradition. The first were the surety laws I mentioned earlier. That is, if you post a bond, you could then keep your gun. That is, the court says, we think you're dangerous. Post a bond. Okay, you post a bond, you keep your gun. That's step one. That's the ex ante, right? There's restriction before you actually commit a crime. Then there's the ex post. If you're a convicted felon, you lose your gun rights. Now, as a practical matter, most felons were executed back in the day, right? So you didn't really have issues of what are the rights of felons because they were killed, they were executed, they were hung, or whatever else, right? But Roberts sort of combined these two things. He combined the ex ante surety laws with the ex post felon disenfranchisement. He combined them, and he just did it so subtle. If you read it, you don't even know what he's doing. And then he combined and say, look, therefore the tradition of taking guns away from someone if they're dangerous, before they commit a felony, before they're convicted. That isn't what Bruin said you're supposed to do, but Roberts modified the framework. He modified the framework. Roberts said that, the law is not trapped in amber, like in Jurassic Park, right? It's not trapped in amber, that we're not stuck with such a rigid application of history and tradition. And Justice Thomas then was left to dissent all by himself, right? All by his loans himself. He's like, where my boy? What happened, right? What happened 2 years ago? I had all of you. Now where'd you go? Why am I all by myself? And Thomas said that in Bruin, they consider the surety laws. They said those surety laws don't support disenfranchisement of firearm rights. So something changed. And I think we could just sort of look at this, just sort of take a step back. The majority didn't want to write an opinion giving a domestic violence bad guy, my daughter would say, he's a bad guy, he's a very bad guy, a gun. They just didn't want that. I think Justice Kavanaugh in particular, with his allegations against him, he did not want to be the opinion saying, yeah, let's give the domestic abuser a gun. That'd be a good idea. So, we can be talking about law for a minute, we talk about politics for a minute. I think this was a case where sort of the optics were just so strong, the court could not affirm the Fifth Circuit. But then that raises the question, right? When the court changes its doctrine, I think they have a duty to actually explain their changing doctrine, right? The Supreme Court, of course, is not bound by its precedents. They can change course. They do it all the time. But I wish they would at least be candid and say, look, well, we wrote this in Bruin. We didn't really mean it. That was like 2 years ago. Here's what we really mean, right? But they didn't. They said, we are following Bruin. Now, the case actually went back to the Fifth Circuit. This happened about a week ago. By the way, when the Supreme Court decides a case, it doesn't end there. Right? They would say, we remand the case to the lower court for further proceedings, right? You always see this. We never actually pay attention. It went back to my beloved Fifth Circuit. And there was a panel of the Fifth Circuit, which involved Judge Jones, who he knows well, Judge Ho, who I have gotten to know very well, and Judge Wilson. And they said, quote, Rahimi Bruin modified, I'll say it again, Rahimi modified Bruin, I said that right, that the Supreme Court in 2024 modified their decision from 2022, not even 2 years old. It was, barely a toddler, right? They already changed it. And then Judge Ho wrote a concurrence saying, we are lower court judges. It's not our job to sort of anticipate what the court might do. And we faithfully apply the precedent. If the court wants to change it, that's the court's prerogative. In other words, don't blame us, right? If you're going to reverse us, say that we screwed up, don't blame us. This is actually a trend last year. The court reversed Fifth Circuit quite a lot when I think the Fifth Circuit was actually applying the precedent that existed at the time. Now, why does this matter? The U.S. government, the Solicitor General wanted Rahimi to be the case they decide. Why? The fact patterns are so good, or actually bad, you might say, for the government. Right? The government wants the domestic abuser. There was another case in Philadelphia involving gun rights. You have Mr. Range. What did Mr. Range do? He lied on a food stamp application. He misstated his income on a food stamp application. He wanted to get some more food stamps. Okay, it's a felony, right? When you lie on a federal government document, it's a felony. I'm not going to excuse that, but come on, right? Dude was hungry, right? He wanted to get some more food stamps. He lied about his income on an application for food stamps. He was charged with a felony. And for the rest of his life, he was deprived of a civil right. Now, you may hate guns, but just pause for a minute. This man wasn't a danger to others. He didn't hurt anyone. He lied like Jean Valjean, right? He was hungry. He wanted some more food stamps, okay? The Supreme Court could have decided the Range case at the same time. And they could have said, well, Rahimi, bad. You can't have a gun, right? And I'm almost done getting food in a minute. But Mr. Range, food stamps, okay, that's okay. But the court denied review in Range. They said, go back to the lower court. So it very well may be that the court decides a case like Range, where they say, okay, if you're a nonviolent felon like Mr. Range, or think of Martha Stewart, right? Martha Stewart owned a gun, right? Fine. But then you have a case like Mr. Rahimi, a bad dude, and he can't have a firearm. The trickier ones, though, are the cases about what kinds of arms can you possess, right? What kind of magazines can you possess? Where can you carry? And I don't know if the court's interested in taking these cases. They went almost more than a decade after Heller and McDonald to even decide Bruin and Rahimi. I think they're kind of just going to stay on the sidelines and let things sort of germinate. All right. Now there's a gun case the court this term, but it's actually a Second Amendment case. It involves what might be called ghost guns. That is a home manufactured guns. I'm actually one of the lawyers in this case, so if you have an interest. But the federal government has reinterpreted some old statutes that basically bar the production of a firearm at home unless you go through this sort of background check and you get a fingerprint and serial number and stuff for the gun kit that you buy. And compressing a lot of issues, but that's not really a Second Amendment issue. But I think what will pretty much happen now is that Rahimi has signaled to the lower courts, we're not going to reverse you if you uphold a gun law. So it was a good 2-year run from Bruin to Rahimi. People got very excited, very upset, but I'm not too much sure what happens now. All right. I see there's nuggets in the back. Is that right?
I don't know what's going on.
Yeah, well, there's some Wendy's there. So.
There's some Wendy's. We're still waiting on the pizza to come down.
All right. Grab some nuggets.
All right.
Go.
So yeah. So.
Would you like some? Do you want
No, I don't want any nuggets. I'm good. Save them for the students. I would never take them.
Got my cucumber. Yeah.
Is it a zucchini or cucumber?
You eat a cucumber raw, just like that?
Mm-hmm.
All right, take a short interlude.
So you can't join us for lunch.
No. I'm right in between.
Do you want us to keep talking then?
What would you like to do?
I don't care.
Well,
It'll probably get here 2 minutes after you start talking. We'll probably be able to-
All right, Sasha, you want to go ahead? All right, well, we'll resume. In the spirit of the Constitutional Convention, we'll keep talking when the food's being served,
okay.
and we'll go
Great.
forward. Go ahead.
Okay. Well, yeah. So, thank you, Josh. This is very interesting. And you mentioned, that one big week in 2022 when all of those cases were decided. And at the time, I was in Germany, and so I was in Hamburg, and I was visiting this one law professor at Bucerius University, and he was so nice. He invited me to his house for a 4th of July cookout and so on. It's just only coincidentally 4th of July. Anyway, and there were all of these law students there, and one of them asked me, you got to understand that all of this, except for the last 3 words, are in German. But he says, as a constitutional lawyer, if I might just ask you, what the fuck?
WTF if you get the
Anyway, so I have some ideas about Bruin and Rahimi myself, but one thing that I want to talk about and maybe get some reaction from you, and also I think for reasons that will become clear, this will be, I think, useful for the students, is a case that we have had right here at Emory. So for those of you who don't know, especially I see a lot of my 1Ls in the audience, we have a number of clinics here, including we have a bunch of child-related clinics that are part of the kind of Barton Clinic complex. And one of the clinics that we have there is the Juvenile Defender Clinic, and the person who runs that is one of my colleagues named Randy Waldman. And so if you're interested in that sort of thing, then I really urge you to get in touch with her, and maybe you might end up working on some of these child welfare clinics. So the Juvenile Defender Clinic, what she and the students who work with her do is they literally go into court and defend juveniles. Many of them are bad people. Not all of them are bad people, but you got to understand, when you are any sort of criminal defender, you are sometimes, and maybe a lot of the time, defending bad people. But you're doing it because it's important. They need a good defense, and sometimes you're also standing for a very important principle that helps non-bad people also. So one of the clients was a 15-year-old. Lives in a bad part of town and carries a gun. And he was charged with having a gun, as he was under whatever age was the appropriate age. And he said, well, the reason I carry a gun is because I live in this horrible area, and so I need a gun. Everyone else carries a gun, and I need to defend myself. So the question was, is it consistent with the Second Amendment to disarm 15-year-olds? And so under Bruin, what you have to do is you have to look at the founding history, and you have to see, is there a tradition at the top from around the time of the founding, and there's an ongoing ambiguity about whether you look to 1791 for the Second Amendment, or do you look to 1868 for the 14th Amendment? This is, after all, state law. But in any event, there's that ambiguity. It doesn't always make a difference, but you have to look to some kind of reference period and ask whether there is there's a tradition of that sort of law. Now the thing is, there is a tradition of various laws against juveniles. For example, laws against sale to juveniles. But the argument that she was making there was laws against sale and laws against possession are totally different. And laws against sale are not really analogous to laws against possession. So this was one of those cases where, on the one hand, as a matter of faithful application of Bruin, I'm not an expert on this, but it really did seem to me like under Bruin, there's not really much of an analog. And in fact, to the contrary, there's a very robust tradition of law-abiding minors carrying guns, like youthful John Adams, all sorts of stories about founding fathers when they're 15, they're going hunting or other things with guns.
Scalia carried a gun on the subway but in the 50s. He was talking about this. He was in the rifle team.
Yeah, that's right. Anyway, but on the other hand, the optics are maybe not as bad as for Rahimi, but I mean, the issue is, suppose that there's no founding era analog for any sort of age limitation. Does that mean that we have to allow 5-year-olds? Now, there is the idea that there are laws defining 15-year-olds in many states as being members of the militia, so that potentially gives you a basis for having a cutoff that's somewhere below the age of our client. But anyway, it was the sort of thing where it looks like doctrinally it might be a solid case, but at the same time, because of the politics/optics, it looks like the courts are going to be very unwilling to make law in the direction you want. It's sort of the same dilemma that you have if you're a First Amendment lawyer defending strip clubs. So anyways, that was an interesting case. It was being argued. Unfortunately, it became mooted for reasons that are both sad and predictable, which is the client
no.
was shot.
Oh man.
But the issue is one that recurs regularly, and of course, many clients are going to take a plea bargain, so it won't show up. But at some point, there may be a client who actually is willing to fight this to the end. And so I just wanted to bring that up, number one, just to give you a sense of this is the sort of interesting case you can work on if you are, I'm not saying every case in the juvenile defender clinic is like that, but at least some of the stuff is like that. So it's interesting for the students, and also I kind of a case study in Bruin/Rahimi things. I talked to Randy and I said, do you think that your case is weaker after Rahimi? And she says that she thinks, no, the case actually still survives Rahimi. But I just wanted to bounce that off of you.
Right. So this actually has come up in a couple ways about age in the Second Amendment. Some states have tried to make the age for buying firearms 21, even though the age otherwise is 18 for capacity. I think that, I'm sorry?
You can't drink.
Trust me, I'm aware. Yeah, no, actually, I'm aware. Thankfully, there's not a constitutional right to alcohol yet. But let's assuming alcohol for a moment. Voting there was a Supreme Court case on voting between 18 and 21. There was Oregon v. Mitchell, a very fragmented case, and eventually we had to have a constitutional amendment to address that issue. I don't think there's any sort of tradition of making the firearm age to be 21 versus 18. In terms of once you go below 18, is there any historical pedigree of disarming people? I don't think there is. I haven't looked at it too carefully. I think for the most part, you have to look at where they're carrying, and even Heller recognized that sensitive places like schools you can't carry in. But I won't say sympathy is the wrong word, but I do have some sympathy for a person who actually needs to defend himself in a rough neighborhood. Maybe his parents aren't capable of helping him. It's not a frivolous argument. I know the optics are quite bad. I think we as a society should focus more on why does a 15-year-old need to have a gun than perhaps arresting and putting him in jail, which probably won't yield too much good stuff anyway. I mean, I'm sure there are juvenile offenses, but this person will have disabilities for the rest of his life as a consequence of that. That's just my tentative thoughts.
So is the pizza all ready for people to get?
Maybe we can do is put one box in each row. I counted about 10 boxes, and they can just pass another rows. Can you do that?
That sounds smart.
You're welcome. So no one get up.
Well,
box in each row.
But I mean, there's also there's
And
also
plates.
the nuggets business. So
You just pass them around.
throw the nuggets.
They'll be gone.
Anyway, and then after a while we'll keep going.
Can I get you something or you?
No, I'm
No,
full.
I'm good.
Just put one box in each row. It's good.
The overall argument for lowering pretty much every savings that we have is since Vietnam,
I did the math. I think there's enough. I was once giving a lecture at U Chicago, and they had these sandwiches with this crinkly wrap, and they would just crinkle. I said, everyone, on the count of 3, take your sandwich out of your box and take it and unwrap it. And I said, 1, 2, 3, and it was just this crinkle sound, and that was great. That was awesome, but it was driving me bonkers.
Yeah.
Those are tiny pizzas. That's like that shrinkflation I keep hearing about. Is that cucumbers? Is that cucumbers?
Yeah. I mean, I've got that. Want some celery?
No, I'm good.
Carrot?
Thank you. I'm good. Thank you.
Got hummus to go with.
Oh, you're very kind. Very good. I'm good.
Yes, Mondays and Wednesdays are the days when we have times for speakers because we're on classes during the lunch period. But not this semester. Monday mornings until noon, literally until noon, I'm teaching law and economics of antitrust. And then from 2 to 4, I'm teaching torts. So we're sandwiched in between my classes, or else I would go out to lunch or whatever.
I think you guys got enough. Usually runs out, so good on you.
I did not want to.
Yes, please. That's fine. Thank you so much. There are now. And, yes. Excuse me? No, here. Do you want loaded ones? There's 2 right there. I'm very sorry about.
Don't apologize.
They did give it to us. I just passed it. Yeah, I just passed it over to him first. Because anything would be like, well, it's all good, I'm sorry. It's not your big boy. I understand. I grew up with two brothers and I never got to see. Both of them were athletes too, so I always got scraps. Oh, yeah. My poor mother spent $500 a week on groceries for those guys.
All right, I think we can resume. You want to resume, Sasha?
Sure.
Okay.
I mean,
You give me chewing your cucumber.
finish chewing after.
Let's go to the lobby and get ourselves a snack, right?
So here's what I think is maybe a more fundamental issue about Bruin and just kind of how you use history to determine the contours of a right. This is something that isn't just specific to guns, but it's analogous to the question that we have long asked for a lot of different sorts of rights. For example, so I say this for the benefit of those who haven't had con law yet. One of the most controversial issues in con law is, are there any unenumerated fundamental rights? Generally, that's a question that goes under the name of substantive due process. And the Supreme Court over time has found a number of unenumerated rights, many of which are still the law today, like your right to send your kids to a private school, have your kids educated in a foreign language, the right of parents to control the upbringing of their children, even if it means not letting them see their grandparents and so on. And then various sort of what has been called at various times right to privacy or whatever. So contraception, until recently abortion, right to sexual privacy. So all of those sorts of things, those are what the Supreme Court has at various times recognized as unenumerated fundamental rights. And so in 1997, they decided a case called Glucksberg, where the question was, how do we decide whether something really qualifies? So we're not going to just take anyone's say-so that, oh, I really feel this right is fundamental to me. And so in 1997, what Glucksberg was about is someone wanted to commit suicide with the aid of a doctor. And said, well, I have the right to commit suicide and I have the right to get a doctor's aid in prescribing the appropriate drugs for me. Now, look, personally, I think that is a fundamental right. And like, if I were writing a constitution, that would be, I'm not going to say that would be the number one right I'd put there, but it would be among various fundamental ones, in the same way that I would put the right to abortion also up there. But the question is not, do I like it, but is it a constitutional right? And the Supreme Court rejected that there was a constitutional right to have assisted suicide, and they gave a framework, and they said you have to look at whether this is the sort of right which is deeply rooted in our Anglo-American tradition. And once you say it that way, it's pretty clear that, even to talk about our right to suicide, in fact, I mean, it's very common to say there's a right to negative suicide, that is the right to reject people treating you, like saying, I don't want to be hooked up to a machine and so on. But the right to positive suicide, like actually taking something, that's something that has been at various times either outright criminal or in any event certainly not accepted as a right. And so you can't say that that's deeply rooted in the Anglo-American tradition. So okay, fine, that's an easy way of rejecting that. For other things like sexual privacy, they came to the opposite conclusion, but I think a lot will depend on how broadly or narrowly you define the right. If you define the right as the right to have gay sex, clearly not deeply rooted, because that has, many times been illegal. But if you say it more broadly as the right to sexuality generally, or the right to sexual privacy and so on, the more broadly you can get a judge to accept that, the more likely they are to agree with you that it's a fundamental right. But what that inquiry does is it asks you to look historically at what laws have existed and what has been illegal or not, and conclude from there that there is a right. And that is analogous to what we're doing in Bruin, is that we're saying that the right to keep and bear arms, it's not just an abstract right, but it's a particular right that already existed at the time of the founding, much like the freedom of the press or something like that. And so when the founders put those words in the amendment, they were meaning to refer to a pre-existing right. Our job is to recover what that pre-existing right was. And so in doing that, we look to history and to see what sorts of regulations there were. So, okay. So we do this in a number of places. Now, let's suppose we found that a particular gun holding, particular practice with guns, let's suppose it was really, there's a very strong tradition that it was illegal. Then I think that you're on solid ground in saying, okay, well, I guess the right to keep and bear arms did not include that, because that was something that was very widely accepted in the founding period. So, okay, if what you're doing now really does fit within this thing that was illegal, okay, fine. But now here's the question is, what do you do with things that were not illegal? Things that were legal. Now, generally, of course, look at America, things are legal if they are not illegal. You don't actually need a law to make something legal. You just need the absence of an illegality. So if some practice was consistently legal, does that mean that it was conceptualized as part of a right? Or does it mean that they said, well, no, of course it's not a right. It's the sort of thing which everyone understands that we could ban if we wanted to. We just don't feel like banning it right now. If you, or like maybe the reason we don't feel like banning it right now is because we don't think that under current circumstances, it's a very big problem. But now suppose you were to talk to all of these educated people in the founding period, and I said, let me pose some hypotheticals to you. What if guns became much more powerful? And what if we could have machine guns? And what if this, that, and the other? And I've never heard of those sorts of guns. You're giving me some kind of sci-fi scenario. I've never thought about it. Well, yeah, I understand. I am giving you a sci-fi scenario, but I want you to humor me on this. And they might have said, yes, if society and technology became like that, of course we think that you could ban those things, but that's not anything like the world we live in now. And so that's why you don't actually observe those laws in the historical record. So I think one way of doing originalism would be to say, what would the educated, reasonable person at the time of the founding understand by the right to keep and bear arms? And that includes not only what they think about current conditions, but also a lot of hypotheticals about what they might think about future conditions. So I would think the answers to sci-fi scenarios would be part of the definition of the right to keep and bear arms. And under that view, having to find a historical analog is not really the right way of defining what the Second Amendment means. It assumes what one of the opinions in one of those cases, maybe it was Barrett's, calls it a use it or lose it approach. That we assume that the founding generation completely covered the field of all permissible gun regulations, and so if they didn't regulate something, then that meant that they thought that they couldn't regulate it consistently with the right. And I see how maybe the historical record might be relevant in figuring out what the right to keep and bear arms means, but it seems to me like Bruin went too far in that direction and said that the fact that you can't find a historical analog means that something is in fact within the right. And so I feel like the second thoughts that people were having in Rahimi were actually well-placed second thoughts, and that maybe those second thoughts were reasons why they shouldn't have signed on to Bruin to begin with.
I agree with that last part. I think I've written this, but for the Dobbs leak, I don't know that Thomas would have kept majority opinion in Bruin. I think after the Dobbs leak, the justice had become isolated, that they were afraid they couldn't trust anyone. They weren't circulating opinions. I think if they had actually more time in Bruin, Thomas would have lost the majority. This actually happened at least twice this past year with Justice Alito, where he lost majority opinions. For whatever it's worth, no one in the Second Amendment community wanted Thomas's approach. Thomas sort of made it up. right? In fairness to him, he made it up. Good for him, right? But that's not what anyone wanted. The reason why is perhaps the reason Sasha mentioned. Looking to tradition, to the use it or lose it approach, isn't really originalism. I mean, it kind of is, but not really. Originalism is what did this mean in 1791 or maybe 1868 versus other approaches. What were people doing in terms of regulating guns in its aftermath? I'll just give you another example. Dobbs, again, decided almost the same week, a couple of days apart as Bruin, was about abortion in the 1860s, right? That was the issue. What did due process mean in the 1860s? There were some jurisdictions that prohibited abortion at all stages. Some did it after so-called quickening, which you may have read about in the cases, and other states that didn't regulate abortion. But to Sasha's point, even where a state failed to regulate abortion, no one at the time discussed abortion as some sort of fundamental right. It wasn't discussed that way. The fact that a state didn't regulate it just means they maybe didn't get around to it. They didn't have the law enforcement personnel. They may have different priorities and so on. So I think it's problematic to looking at the law or the absence of law. He mentioned Randy, my colleague Randy Barnett takes maybe a different approach, asking what is the government's power to regulate firearms? And I think a general principle that might be adopted is one of that there is some history of disarming people who are dangerous. And I'm probably okay with that sort of rule, without going through every single regulation ever passed. The challenge, though, was again mean for someone to be dangerous. Now, of course, Rahimi, you are a dangerous person, right? You're shooting people up. But I like to think that there's a presumption of innocence, that people are innocent until proven guilty. In truth, Rahimi should have been a due process case, right? I think depriving people of their rights based on an ex parte hearing is really problematic. But this case arose not as some sort of collateral challenge, but as a direct appeal. And the only ground of the challenge was the Second Amendment, which is more or less a facial challenge, so he was limited. But I think if this exact same case arose where a person filed some sort of a suit against the state saying you've deprived my arms based on this ex parte hearing, I allege due process violation. That thing is a very different case and actually may come out a little bit differently. But again, if you're convicted of a white collar offense like a Martha Stewart or like someone who engages in food stamp fraud, I just really struggle to see why the government should have the power to disarm you if not proven any threat to others. I would use that approach, which Barnett and others like, but the Thomas approach, which is sort of around but not really, makes us then go picking out, well, this law and this law and this law and this law, and that doesn't really sound originalist-ish to me. It's more traditionalist, which is what Justice Kavanaugh prefers.
Yeah, and in fact, I think there's a pedagogical point here, which is that people think about originalism as being, it's all history. It's all, history uber alles. But the reality is that, yes, originalism does want you to look at history, because it's just like, as you're covering in leg reg, there's the textualist approach says you look at the meaning of words from the time when whatever statute was adopted. Mm-hmm. And so, yeah, we want to look at the meaning of words. So we do look at a specific type of history. It's just a caricature. I'll call it lexicographical history or something. That you look at the meaning of words, like the ideal is that you would have a perfect dictionary or something like that. You don't necessarily look at people's intentions at the time. You don't look at what they expected the law would do at the time. You may, but only to the extent it gives you evidence as to what the words meant. Mm-hmm. So originalism calls for a historical inquiry, but a very tightly focused one. Mm-hmm. But some people, when they use originalism, they think that, anything that relies on some people, when they use originalism, they say anything that relies on history. And also some critics of originalism will do the same thing. And they'll say, oh, yes, well, you're doing originalism wrong because you ignored this, that, and the other history. And so I think the moral is, yes, originalism calls for history, but not all uses of history are originalism. I agree with that. And also, there are different originalists who, as we see in the various opinions, even the practice of originalism is contested. And some people actually do believe in intent. Some people believe in original public meaning or original expected applications. Depending on what you agree with, that will imply a different appropriate historical inquiry. Mm-hmm. And here's one thing that I'm not going to say it drove me up the wall. That is a little bit pushing it too far. But I was just reading Bruin and Rahimi last night, and the rhetorical stance of the justices there, and I'm especially remembering it from Kavanaugh, but I mean also Thomas and Roberts. They rejected this traditional tiers of scrutiny. A balancing approach where you look at strict scrutiny or intermediate scrutiny and you say, well, what's the government's rationale and is the government's rationale good enough? And so it does involve a kind of balancing. And they're always caricaturing tiers of scrutiny as being, that's just an untethered policy analysis where the judge can impose their own views. On the other hand, history is great because history is objective. And now, look, I certainly think there's something to that. I think that, history might be the right approach in the abstract, but also I think history might discipline what otherwise would be the policy preferences of judges. But I think you can certainly push that too far. And so, like what we're just saying about how do you interpret the fact that a particular jurisdiction failed to illegalize something? Sometimes we should consider it to be no evidence at all. Sometimes, on the contrary, we say, oh, you see, that means that they thought it was a right. And there's so much, just from looking at the opinions, there's so much controversy over what a particular historical piece of evidence means. And the way someone resolves that controversy might be very motivated by what their policy preferences are. And conversely, tiers of scrutiny, I mean, you could have strict scrutiny. And so even though, yes, it is a balancing, but you could have a kind of scrutiny that really tightly controls policy preferences. So I think that, I understand why rhetorically they're saying that history is opposite from policy and history good, policy bad, but I really think they overdo it.
All right. Maybe we take some questions from students. I'll make sure it leaves time. So what do you have in your minds? Yes.
Jack.
With respect to the Bruin history and tradition and text you kind of have where you're looking for analogous laws, even if it's not necessarily exactly analogous, it kind of begs a couple of questions. Like, first of which is, in you guys' opinion, what is the proper time frame to analyze? Is it like up to 1789 or something like that? Or because I know in a lot of the appellate court cases where the Bruin test is being applied, you have like the state trying to argue all the way up to like the 1860s and almost like Jim Crow type laws, which is quite frankly bad optics. And then the other question is, if not the tradition test, like, can you think of a good substitute for like an actual practical test that can be implemented in evaluating the constitutionality of Second Amendment related laws?
Right. So there's a lot there. I want to just unpack it one step at a time. So the first question is, what is the correct temporal framework for originalism? In Heller itself, there was actually a dispute between Justice Scalia in the majority and Justice Stevens in dissent. Scalia's majority goes back to the 1600s in England and the English Bill of Rights and goes to the founding and so on. And then he sort of tiptoes a little bit further beyond the framing. He looks into the early 18th century, almost the antebellum era. And Justice Stevens says, what are you doing, Nino? Why are you looking at the stuff after ratification? What difference does it make? And Scalia responds, when you have a constitution drafted and Bill of Rights ratified in 1791, and you have a consistent set of understanding for the decades afterwards, that reinforces what the original meaning was. So Scalia says, where the history after ratification is consistent, it reinforces the original meaning. Okay. But then again, Heller was only a case about the federal government. Then we go to McDonald. McDonald was a case about incorporation, which really means the 1860s, right? I won't bore you with it, but there's a long-standing debate about what is the correct vehicle to incorporate rights. Is it the due process clause? Is it the privileges or immunities clause? And the majority is like, okay, we'll do due process, which is a very unoriginalist approach. Thomas is like, no. There's evidence that people in the 1860s spoke of the right to bear arms as a privilege or immunity of citizenship. It was in the Freedmen's Bureau Act and these various pieces of legislation. And the court wasn't interested there. So at least even a decade ago, the court didn't really care about this temporal framework. Then more recently in Bruin, again, the court was somewhat unclear what the correct standard was. And Justice Barrett's like, why are we looking at this other stuff? Justice Kavanaugh wrote a concurrence in Rahimi saying tradition, he loves tradition. Tradition's so important because it tells us what the people understand the rights to mean, which goes to, well, if they regulate something, is that a right or the absence of a right?
The people. Tradition.
I make this joke all the time. Finally, someone gets it.
Fiddler on the Anyway.
Okay. I stopped using it because they don't get the reference, so I stopped doing it. But Justice Kavanaugh loves tradition. Now, if you were to ask me, and I think you did ask me about my approach, I would probably favor the Barnett approach, which focuses on the scope of governmental power and not trying to pick and choose various laws that came 100 years later. And just to give an example, the law in Bruin was called the Sullivan Law, right? Restricted gun ownership in New York. It was over 100 years old. That's a tradition. None of us were alive that long. Now, the origin of the law is not very pleasant. It was designed to basically disarm Irish and Italian immigrants. Yes, if you want to know about gun control laws, they were racist laws. Which states had the most aggressive gun laws? Georgia, to disenfranchise the freedmen. Trust me on this. If you want to look at this history, it's not pleasant. In fact, in the lower courts, governments have actually cited a lot of Jim Crow laws saying, look, we have all these gun control laws. And when they get to the Supreme Court, never mind, we don't want to cite those. I think Justice Jackson said, so why did you cite these laws anymore? You cited them in the lower court, and there wasn't a very good answer to that because it's like, never mind, we just don't want to touch that. So, I mean, look, you have a lot of these laws that are just not very nice to cite. You don't want to cite them because the history there is kind of ugly. So I didn't answer your question at all, but there's a lot of things that might be worth thinking about there.
My view is that, well, at least if you're talking about a federal government case, so let's say a case like Heller, so just the District of Columbia, it's just the federal government, no state involved. So then I would say 1791 is the only thing we care about. Now, what that means is hypothetically, if everyone had written treatises in 1791 that completely answered every question, then we would only look at those and we would not look at anything else. Now, the reality is we don't have all of those magic complete treatises, so we need to look at various pieces of evidence. And so anything not from 1791 is only potentially useful as an evidentiary matter. So, for example, we can look at, there's certain right, like the Second Amendment has a clear analog in the English Bill of Rights of 1689. And so, we can look at that, and we can look at, state constitutional provisions from the early founding period and other things. So, and that's useful to the extent that it tells us what it meant in 1791. In that sense, the Statute of Northampton from the 1320s is not interesting in itself, but it's only interesting to the extent that it actually it informed the common law baseline that our founders, who were also British lawyers, knew about. And then similarly, what about the post-enactment stuff? That also, to a certain extent, so sometimes the Supreme Court will say, here's a statute that was passed in the first Congress in 1789, and that is strong evidence of what it meant just a couple years before. Now, again, only evidentiary, like Marbury v. Madison shows that even the first Congress can violate the Constitution.
Or that John Marshall's wrong.
Or that John Marshall's wrong. But in any event, we don't want to assume that the government that's supposed to be regulated by the Constitution always magically follows the Constitution. So I think that anything that is not from 1791 is potentially useful, but as an evidentiary matter. So if you have a tradition that started in 1791 and continued unbroken for the next 100 years, then you can use that, but only because it's unbroken and because you can say that it's that it informs our thinking about 1791. So having said that, what happens when we get a state case that's about 1868? Now, what I would say is we have a nice rule that various cases have set. And the rule is that when you have a law, when you have a right that applies against the federal government and state government, it's just convenient for us to say that they're exactly identical. And it has a lot of convenience to it. And it comes from how we accepted incorporation over the course of the 20th century. Maybe that was right or wrong, but that ship has really sailed there. So that's what I would call not a question of original meaning, but just a rule of construction. And so there's a distinction between interpretation and construction. Some people talk about that. And so I think that sometimes it's just actual courts in their actual work have to come up with methods, just ways of doing their work. And so like I favor a rule where we look at 1791 and then we assume that the 14th Amendment was kind of referring to terms of art that incorporated the 1791 meaning. So I wouldn't look to particularly 1868 meaning separately.
Okay, I think we're almost at time. Maybe one more question? Yes, go ahead.
I'm curious to hear your thoughts about, from an originalist perspective, where you would draw the lines on what are arms and what kinds of things implicate the Second Amendment. Like, and in view of like new technology, how today, like we're talking about block switches.
Yeah.
Where could you draw the line?
Sure. So Heller was very opaque in this issue. And they said weapons in common use, that's what arms are, they're protected. And Heller also said you can't have a dangerous and unusual weapon. And it's dangerous and unusual, not dangerous or. A lot of courts have changed the and to an or, which is significant. So we have common and not unusual. Common, unusual, kind of opposite. So if it's common, it's not unusual. One of the most popular common weapons in arms today is the AR-15, without question. So I mean, you have a lot of these laws banning AR-15s. I think that's hard to reconcile with the plain text of Heller. The problem, is, as you suggest, is that there are new types of devices and new types of weapons. So it's a Glock switch, if you know what this is. It's basically a little thing you put on a handgun, which can somewhat easily convert it from a semi-automatic that's firing one bullet at a time to a full automatic, which just sprays bullets randomly. Is the Glock switch itself an arm? I think it's safe to say under modern law that machine guns are not very common. Why? Because they've been heavily regulated for the last 90 years or so. So it's a sort of this weird thing where you're interpreting the Second Amendment after decades of other types of laws being in effect. And the guns we have today are a direct byproduct of laws that were enacted before the Second Amendment had any teeth. So I don't have a clear answer on the Glocks. I think that the courts would probably hold that the automatic weapons are outside the scope of that. But I'm more confident that the AR-15 would be covered. Justice Kavanaugh suggests as much as the lower court judge.
I would think that there's one problematic thing, and this struck me when reading Bruin and Rahimi yesterday, that it's one thing to say it protects guns that are in common use at the founding, and it's another thing to say that the idea of being in common use is itself dynamic and protects at any moment those guns that are in common use at that moment. That seems to be an extra stretch, and I'm not sure whether it's one that's warranted, but that gets to my general critique of Bruin, that there might be certain guns which the founding generation would have regulated if it had imagined them, but it didn't know about them, but it would have been part of the right to the contours of the right to begin with. And so I think that's one reason why, for all that people say about these tiers of scrutiny, that's at least something that the tiers of scrutiny approach has to recommend it, which is that it does have the flexibility to.
Okay.
Another question regarding common use and whether or not it's sort of a dynamic standard. We have from Heller is common use for lawful purposes. Like Glock switches, for instance, it's like an extremely mechanically simple device that costs like 76 cents to make. And they're typically made in China and shipped overseas in bulk, 500 at a time, and disseminated illegally. But a lot of the time, like going back to the case you mentioned, where you have a teenager who's using a firearm presumably for illegal but arguably
Self-defense,
which is a lawful purpose. Do you think there could be a threshold where you have devices that are basically totally illegal, but they reach a certain threshold of common use for lawful purposes, even though they themselves are at present illegal by statute?
Yeah, that might be a justification for machine guns. Those are not. You always see the machine guns they're very dangerous weapons to actually hold. If you ever fire one, you have almost no accuracy at all. These are not good weapons used for self-defense. I mean, maybe in some rare circumstance. I think what I would just say, and we'll end here. I know we're over time. Is that the lawful purpose is significant? I mean, people say, what about a right to a bazooka and a right to a nuclear bomb? No, right to anthrax, right? And no, I'm serious. People have, it's an arm. People use it as a chemical weapon, right? I think if you have the lawful purpose hook in there, it does cabin the sorts of weapons that might be suitable for the Second Amendment. All right,
I think we're
Thank you
all
so much.
done.
Thank you, Sasha.
Thank you all for coming. Our next event is next week. It's a debate on attorney discipline and free speech with Professor Kavanaugh and Ted Frank.
Oh, Ted's a good friend.
Yes.
Good.
So we'll see you all there.
He lives in
Thank you
Houston, so we're
much.
just going to switch
Oh, does he live in Houston now?
part of the year.